Thank you for attending Unchecked Power of the Ohio General Assembly. Can legislators override voters' will on marijuana reform? The event is hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for this event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. A link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Doug?
Thank you so much, Holly, and thanks to everybody at the Drug Enforcement and Policy Center for helping us convene this conversation. I'm Doug Berman. I am the director of the Drug Enforcement and Policy Center, and very excited to be able to have an hour to talk to three very smart folks about what we've seen with respect to legislative efforts to amend Ohio's vote to legalize recreational marijuana. As many of you know, probably who are tuning in, and I'll provide a little bit of background here, when Ohio legalized adult use marijuana back in November of 2023, it did so through a citizen-initiated statute known then as Issue 2, and that was approved by voters by a pretty significant margin, 57% to 43%. But unlike a voter-approved constitutional amendment that generally cannot be altered by regular legislation, the marijuana vote was for a citizen-initiated statute that allows the Ohio General Assembly to make changes to what voters approved in the law through follow-up. Perhaps not surprisingly, since the passage of Issue 2, we've had the Ohio General Assembly discussing and introducing multiple bills, including some provisions in the biannual budget bill that's about to be finished this month, proposing a range of changes, some quite significant, and eliminating certain provisions of the voter approved statute. Some contend, including Derek Klinger, who's with us today, that the Ohio Constitution speaks to what changes can be made or cannot be made, even to a initiated statute that the voters approved, that Issue 2 was a version of, arguing that the legislative power to amend only allows changes that facilitate what voters approved rather than limiting or restricting that. We're going to hear from Derek directly talking about his view of what the Ohio Constitution allows or does not allow. And with that, let me actually introduce our three panelists, do a little bit more background about what we've seen in this space, and then focus on the argument that what the legislature may be trying to do may extend beyond what the Ohio Constitution allows. So I mentioned Derek Klinger. He's senior staff attorney with the State Democracy Research Initiative at the University of Wisconsin Law School. I believe he's also an alum of the great Ohio State University Moritz College of Law. Then we also have with us Karen O'Keefe, who's Director of State Policy for the Marijuana Policy Project and the MPP Foundation. And then we're also lucky to have Patrick Higgins, Policy Counsel at the ACLU of Ohio. And I provided a very basic introduction to kind of what we're talking about here today. But I think some of the substantive particulars, and I will say part of the conversation we've heard from the General Assembly is, well, voters don't really understand or care about the substantive particulars of what was voted on in Issue 2. They just were thinking about whether to legalize adult use marijuana or not. But I think the substantive particulars are quite important, and maybe even we could get some discussion about how that's been implemented since the vote passed back in November 2023. We're almost 2 full years since voters approved that ballot initiative. And so Patrick or Karen, I don't know if you want to speak to a little bit just some of the substantive basics of Issue 2 and how you view implementation going in the law that's still right now the law of the land, because none of these legislative proposals put forward by the General Assembly have made it all the way to the governor's desk to be signed. So the state of the law is Issue 2. Love to get your view, maybe from both of you, just a little bit about what you think are some of the highlights of what's unique or valuable in Ohio's legislation, and then some of how that's been implemented, and maybe some of the sticking points of the conversation about what may or may not need reforming. Go
Sure,
ahead,
I
Patrick.
can get us kicked off. Thank you
Great.
for the kind introduction and for having us, and for all of you for tuning in to learn more about this. Like Doug said, I'm Patrick Higgins. I serve as Senior Policy Counsel at ACLU of Ohio. ACLU of Ohio endorsed issue 2 when it was going to the ballot for 2 primary reasons, which are our primary focuses on cannabis legalization, which is both legalize and repair. Repair meaning repair the past harms of the war on drugs, specifically cannabis. So, as we all know, as Professor Berman pointed out, issue 2 passed pretty resoundingly. A 57-43 swing in a state like Ohio is a pretty big deal. We've seen some folks cast some doubt on whether or not that's a resounding victory, but when we look at it, 14 points is a pretty clear message from Ohio voters. So, I mentioned before, legalize and repair. We saw issue 2 stand up a legal, regulated adult use cannabis market, and also took some steps to repair that second piece by establishing different programs and funds through the 10% excise tax that's levied on recreational cannabis sales in the state. What those sales were, or what that funding was supposed to do, was fund a few initiatives that we believe voters knew about and that they resoundingly endorsed at the polls. So, quick breakdown, then I'll yield to Karen, let her fill in some of the other details as well. 36% of that 10% excise tax was to go to the Cannabis Social Equity and Jobs Program. You can find that if you're, a real, policy wonk nerd like myself, in section 378019. I'd be happy to send around some information after the fact as well. But that funding was supposed to go to things like studying, funding criminal justice reform, looking at these past harms that we're thinking about, funding specific programs that would allow folks who bore the heaviest burden of the war on drugs to get into the market, participate in it, and create some equity within the industry where the medical process was already underway, and many of our current market was already off to a running start before many folks had a chance to catch up. 36% of that 10% excise tax is also supposed to go to a host community fund. I imagine we'll talk a little bit more about where that stands later. 25% to a substance abuse and addiction fund, and 3% to the Division of Cannabis Control Tax Commissioner Fund. To put that in some context before I stop talking, taking up space, as of, I think, yesterday, the most recent sales numbers came out. 36% of that 10% excise tax amount would put us somewhere in the ballpark of $20 million in each of those 36% buckets. So we're talking about already, thinking, June 10th of 2025, $20 million that should be earmarked for something like the Social Equity and Jobs Program or the Host Community Fund. As we know, the story that's coming through the rest of this webinar, lawmakers have other plans, and it's something that we oppose in the state legislature. So I'll wrap with that. I know Karen's a much bigger expert on some of the rest of the area of law, and Derek as well. So thank you.
I appreciate that, Patrick, and I think you're very nicely zeroed in on the tax piece. We've been doing some work at the Drug Enforcement and Policy Center trying to cover the reality of how taxes are allocated in other states that have legalized adult use, and the way in which, as you mentioned, there were these pretty specific allocations built into the legislation that was voted on back in 2023, and it seems like that's the most sort of tangible piece of what the General Assembly has been talking about, changing and changing quite dramatically. But there's a lot else going on as well, Karen. I wonder if you can speak to some of the regulatory pieces, and again, like Patrick mentioned as well, highlight perhaps points that looks like the General Assembly is most eager to modify.
Yeah, so starting in December of 2023, it became legal for adults 21 and older in Ohio to possess, share, and cultivate limited amounts of cannabis. And people have been doing that ever since. We've heard testimony of people that were cultivating cannabis, sharing it with neighbors who had multiple sclerosis or other very serious illnesses, and that has helped them. They've been free to use cannabis in their own homes. Businesses are supposed to be allowed to use it, except you can't smoke cannabis or use it in public places. Things that haven't happened that were supposed to happen. So sales of legal regulated cannabis to adults began through existing medical cannabis businesses that were then dual licensed last August. However, the DCC, Division of Cannabis Control, was supposed to also license new licensees. There were supposed to be 40 new, what were called level 3 cultivators, and up to 50 new retailers, with a prioritization of the Social Equity and Jobs Program. That has not happened, and nothing has happened to bring to fruition the very important piece of the initiative to have a social justice, social equity, and jobs program to reinvest in and to support and to create opportunities for those communities that have been most impacted by the war on cannabis in Ohio.
Yeah, and thank you for bringing that up, because I think it's a very valuable point to highlight that the conversations that have been going on at the General Assembly about reform have, in some sense, already deterred or diminished the work being done under the statute that was passed, even though that's still currently law. My understanding and my sense has been that Department of Development has been disinclined to move forward with that social equity and jobs fund, because we've been seeing proposals coming out of the General Assembly from the get-go to eliminate that. My understanding also is that money hasn't been allocated, partially because of just the technicalities of getting those early tax revenues to the different departments that have been earmarked to get it. And as a result, everyone's kind of waiting to see what the General Assembly is going to do. My understanding, and I think this is partially, we've heard this indirectly from Governor DeWine, who himself proposed some changes in his suggestion of the budget, that whatever the General Assembly does, Governor DeWine's going to sign off on that, that ultimately he's not going to be a limit on what kind of modifications the General Assembly is going to make. And I'm just sort of curious, and we'll go to Derek in a minute to talk through what he thinks might be some constitutional limits on the changes that can be made. But just to try to get your sense, Patrick or Karen, what are particular provisions in the General Assembly's reforms that worry you the most, or that you think are kind of most inconsistent, or at least if we were getting in Governor DeWine's ear, and I believe he does have a line item veto authority if he wanted to preserve certain things, even if the General Assembly passes a change, that you think are kind of most inconsistent, most distinct from what the voters approved our first time around.
I could take a first stab at this.
Right,
be not surprised to hear that my comments will mirror kind of what I set up at the beginning. Again, the reasons that we endorsed issue 2 to begin with, both legalization and repair of past harms. Right out of the gate, we saw in the original version of Senate Bill 56, which came from Senator Steve Huffman, some really troubling language from the get-go. One, we saw a tax increase with that money going to the general revenue fund rather than that kind of breakdown that I outlined before. We saw increased criminalization of cannabis use. I think among the most egregious things was a mandatory minimum 3 days in jail for a passenger who vaped, smoked, or combusted cannabis, again, as a passenger in a vehicle. No language about whether it was moving, but we saw this kind of strict or a restriction of cannabis use to individual personal residences are the words that are being thrown around. And so, thinking back to this of who this language benefits, who's getting the most out of the legislative process as this gets amended, we see a growth in some areas that significantly supports the cannabis industry and restrictions on the individual rights of folks who turned out for this at the ballot box. Also concerning to us, that kind of wholesale elimination of the tax structure that voters approved. I understand there's some technical concerns from folks in the General Assembly. However, I will point out that, and as does Derek in his article, lawmakers through this initiated statute process had their opportunity. They had over 4 months to take a look at this language, amend it, hold hearings on it, and they did nothing, which is what took it to the ballot in November of 2023, which is what makes some of these rollbacks particularly egregious, in our opinion. And so, we would have been happy to have participated in the legislative process then, and we are, willing participants now, but would have loved to have gotten this right before we stand where we are today.
Thank you, Patrick. I appreciate that, Karen. And then we're doing a nice, I think, lead up to Derek, but other aspects of either what's been discussed or just sort of components of what the General Assembly has been moving towards that seem, to you particularly concerning in light of what already is law in issue 2.
Yeah, so the proposals started out way more extreme in terms of recriminalization, hiking up taxes, and removing all of the allocations that were included in issue 2. And they've throughout time gotten slightly less terrible, but are still inconsistent with the intent of voters. So when the Senate opposed legalization before issue 2 passed. They passed a resolution in opposition to it. Their initial bill would have completely done away with home cultivation and made a bunch of other very egregious changes. That bill died in the House last year. Then we had new elections, and there's different House leadership this year. This year, the Senate passed a bill that you couldn't smoke in your backyard. It had initially an increase in the taxes and was otherwise pretty extreme. It had that 3-day mandatory minimum for smoking in a vehicle or vaping in a vehicle as a passenger or on a boat. And there was just a substitute bill. The bill is SB 56 in the House Judiciary Committee. That is an amended version that, again, has less recriminalization. It does not have the increase in taxes. It preserves some of the revenue for municipalities at 25%, which is an increase from what it initially had at 20%, but is way less than the 36% that is in the voter initiative, and it doesn't have any of the other allocations. So the remaining concerns for us include some recriminalization. So any cannabis somebody possesses would have to be either homegrown or from an Ohio licensed retailer. So if you pass through from Michigan, which is where I live, or purchase cannabis somewhere else, you would still be a criminal. You'd be a criminal again. Or if you just couldn't prove where your cannabis came from, it would open the door to those kind of interrogations. You also could only share cannabis that was purchased. You couldn't share homegrown cannabis. So the people that are helping out their neighbors with serious illnesses couldn't do that anymore. And if they shared more than 20 grams, they'd face a felony for doing so. And you could only share cannabis in your own home. And as was mentioned, it also does away with the entire social equity and jobs program. It also puts a cap on the total number of retailers in the state at 400, and it gets rid of these level 3 small growers and legislatively would do away with those new licenses, the 40 new growers and the 50 new retailers that were provided for in issue 2. So it still has a lot of alarming provisions, but is not quite as terrible as the initial proposal.
Thank you so much for that. Oh, go ahead, Patrick.
If I may, I think I skipped over the part of your question, just kind of setting the legislative scene for what we're working with in the Ohio General Assembly. So for folks who are less familiar, the General Assembly of Ohio works in 2-year cycles, one that turned over just in January of this year. So when you're thinking to yourself, what caused this switch and kind of the momentum of the rollback legislation, I think it's important to mark that point where the 136th General Assembly started in January of this year. So in the 135th last General Assembly, different speaker in the House, different leadership in the Senate. And we saw what previously stalled due to some schisms in the majority caucus turn into this kind of effort that we see now, where there's the same amount of resistance, I think, from folks in the general public, but the political will and landscape has changed a bit. While the numbers have changed in the House and Senate just a touch, the majority caucus, the Republican Party, again, shared by the governor and other statewide offices, still slants very heavily in favor of the majority caucus in both the House and the Senate, including one that surpasses, some of that. I think we're firmly in a veto-proof majority as well. And so when we're talking about the citizen-initiated statute or other citizen-initiated processes, usually tools that folks take to the ballot when they feel that the legislature is unresponsive to their wishes, we see a very troubling landscape when there's unchecked power, hence the name of the event. So just wanted to plug that in there and give folks an idea of what we're working with in the G.
I really appreciate that, Patrick, and this is in some sense a good setup to we're going to hear from Derek, because all of this legal and policy discussion comes against the backdrop of the basic framework of direct democracy, where we see, and it's not universal, we obviously don't have it at the federal national level, but a majority of states have some mechanism for voters to speak directly through the ballot box on particular issues, and that's often invoked only when the General Assembly or legislature isn't being attentive to the majority's interests. And we've actually seen this quite widely when it comes to marijuana reform, starting with medical marijuana reforms, that were done by initiative in California going all the way back to 1996, and then a wave of adult use reforms as well. And I believe the majority of our representatives were opposing these reforms at every stage of the ballot process in different iterations. And that's where we get to this core intrigue that is not quite unique to Ohio, but distinctive, than some others where we have two different ways to pass laws. One's by constitutional amendment that then locks that into the Constitution. And there was in earlier versions of full legalization debates, we shouldn't do it in the Constitution because then you can't modify and tweak it. And that's an argument against the proposal in and of itself. This one was done in the initiative posture, the statutory initiative posture, which did mean the General Assembly would be in position to do some subsequent modifications. But Derek, I think most folks have been talking about listening to this debate just in pure policy terms. Well, the voters voted for something. There's a policy argument about whether home grow or tax rates or whatever it might be should be X or X plus 1 or Y, but that's to be debated in only policy terms. And then you drafted an article that we saw that we thought was very important to discuss, which is, well, no, there may be some constitutional limits here, and we're eager to give you your time to both explain the broader background of your article and its importance, not just to the cannabis debate, but to initiative statutory reforms in Ohio more generally, but then particularly to give you a chance to talk through and highlight how you think it might impact the discussion still ongoing about possible reforms to issue 2.
Yeah, and thank you so much, Professor Berman, for having me and organizing this event. So this is the central issue of an essay I have coming out in Case Western's Law Review. Yes, thank you for linking to that. And so throughout these debates over whether and how to change this law, there's been an assumption that the General Assembly has the complete discretion to change or even fully repeal the initiative. And I think this belief really stems from the Ohio Constitution's silence on this issue. It does not address this scenario in explicit terms, leading me to believe that because legislative alterations are not explicitly prohibited, lawmakers must be free to make them. Some also point to other state constitutions that do explicitly restrict legislative alterations of initiated laws, and again, arguing that Ohio's lack of language like this, again, must mean that lawmakers are free to alter initiated laws. But Ohio courts have never actually weighed in on this issue, leaving it somewhat open and unresolved. And as I also discovered, nobody's really investigated this particular issue either, hence why I wrote an essay about it. So my main takeaway, which I'll explain, is this. When you look closely at the text, the structure, and the history of the Ohio Constitution's statutory initiative provision, it strongly suggests that the Constitution places real limits on the General Assembly's power to alter initiated laws. Now, to be clear, I don't think the Constitution completely prohibits the legislature from making changes, though I actually think there's a better argument for that position than for the one that says the lawmakers have complete discretion to change initiatives. But I do read the Constitution as significantly limiting lawmakers' power here. And the emerging standard, which again I'll explain, is that lawmakers can amend an initiated law only if the changes facilitate the initiative without in any way limiting or restricting what the voters approved. So just as kind of an initial point, this issue turns on the meaning of the Constitution's statutory initiative provision. So I think it's worth stepping back for a moment just to say a few words about the Constitution and the initiative process. Professor Berman's already previewed some of this too. I mean, the Constitution is the fundamental law of the state. It comes directly from the people of Ohio. The preamble makes this point, stating that the Constitution derives from the people of Ohio to secure its blessings and promote our common welfare. And the Constitution also has its own Bill of Rights, which, among other provisions, reaffirms that all political power is inherent in the people, and that government is created for their equal protection and benefit. The Bill of Rights even guarantees that the people have the right to alter, reform, or abolish the state government whenever they see fit. And so it's through this document that Ohioans created the structure of the state government, including establishing the General Assembly and its powers, as well as the Ohio Supreme Court, the governor. And in 1912, Ohioans amended the Constitution to give themselves this direct lawmaking power through a statewide initiative and referendum. And as Professor Berman said, that's pretty special. Nothing like that exists in the U.S. Constitution. And 20 other states have this specific power to where voters can propose laws directly to their fellow citizens by initiative petition. So this language was put in Article 2 of the Constitution. And when you look at this text, several provisions point to there being a limit on lawmakers' authority to legislate in the area of the initiative power. Just the first point is the initiative power is introduced in Article 2, Section 1 as a reservation of legislative power by the people of Ohio to the people of Ohio. And this just gets back to that broader point I was just making. Ohioans gave themselves this lawmaking power. It did not come from the General Assembly. And the effect is that the General Assembly is in really a power sharing arrangement with the people of Ohio when it comes to lawmaking. And now, after that, the Constitution then lays out in considerable detail how the initiative power is to be exercised. The relevant provisions are over 1,500 words long, which is a lot for a constitutional provision. Just for context, the Ohio Constitution says more about the statutory initiative power than the U.S. Constitution says about the president and federal courts combined. So that's a lot of detail, and it was quite intentional, with the idea being that if the key mechanics are all set forth in the Constitution, it'll be harder for lawmakers to undermine that power down the road. Now, as an important part of this highly detailed process, which is something Patrick alluded to or mentioned, the Ohio Constitution actually gives the General Assembly an opportunity to amend a law proposed by initiative petition and potentially pass its own alternative. But very importantly, that opportunity is limited to a 4-month window that would precede any election on the proposal. And the way this works is that if the people circulate and file a petition proposing a statute that contains a sufficient number of signatures and complies with other legal requirements, the law does not immediately go to the voters for a vote, but first goes to the General Assembly, which then has 4 months to consider the law. The Constitution then gives legislators 3 options during this 4-month window. They can pass the law as proposed, pass an amended version, or decline to pass it, or otherwise just take no action on it. And the Constitution also specifies the outcome of each option. If the law is passed as proposed by the petition, then it goes into effect and there's no need to hold an election. On the other hand, if the law is passed in an amended version, or lawmakers otherwise don't pass the law as proposed, then voters can circulate a second petition to place their proposal on the ballot, allowing the people to decide whether they want it or not. And that's what happened with this marijuana initiative. So after this 4-month window, the Constitution does not provide any further legislative involvement with the initiative process, except for what I've referred to as an anti-subversion provision at the end of Article 2, Section 1G. And I'll get to that in a few moments. But no further legislative involvement after this 4-month window, which to me implies that lawmakers' authority with respect to the initiative process is really confined to what the Constitution expressly permits. Otherwise, this detailed process would be somewhat meaningless and could be easily circumvented. There are a couple other just kind of key structural points, which I'll just touch on real quick. One is that the Constitution unambiguously spells out the effect of voter approval on initiated statute. It says in 3 different ways that a law approved by the voters shall take effect without any further qualification. It also provides that an approved law is not subject to a gubernatorial veto, which again just kind of further reinforces this idea that elected officials cannot undo the will of the people. Another quick point is that the Constitution actually provides for other explicit limits on the statutory initiative power. It expressly extends constitutional limits on the General Assembly's lawmaking power to citizen initiatives. So, for example, an initiated statute would have to comply with the same single subject limit that the General Assembly has to comply with. And second, the Constitution expressly prohibits the use of the initiative to impose what is referred to as the single tax, which was a contentious taxation policy from progressive era. So what this shows to me is that the framers of the provision knew how to write clear limits on the power, yet they didn't expressly state that the General Assembly would be free to change or even repeal an initiated law after an election. And so the last structural point I want to flag comes at the very end of the initiative provision. So after detailing all the substantive and procedural requirements of the initiative and referendum petition, Article 2, Section 1G contains one last protection, an anti-subversion provision, which reads as follows, and I'm just going to read it for you guys. The foregoing provisions of this section shall be self-executing, except as herein otherwise provided. Laws may be passed to facilitate their operation, but in no way limiting or restricting either such provisions or the powers herein reserved. End quote. So of all the constitutional provisions, this anti-subversion clause seems to most directly address the scenario of whether legislators can amend or repeal voter-approved initiatives. They can, but only if the change facilitates the initiative without in any way limiting or restricting it. Now, there's limited case law interpreting this particular provision, but a few Ohio Supreme Court cases just issued a few years after the initiative provision was added confirmed that the provision was intended as a safeguard for the initiative, and that it should be understood as really the sole grant of power for the General Assembly to legislate on anything related to the initiative power that is otherwise not provided for in the Constitution. And so given that the Constitution does not otherwise specifically address whether the General Assembly can amend or repeal an initiated statute after the election, I think this anti-subversion clause would seem to control, with the rule being legislators can pass a law altering a voter-approved statutory initiative, but only if the law facilitates the initiative and in no way limits or restricts it. Yeah, I'll just in my essay, I also dive into the history, but I won't get into that because I know I'm already running over.
It's wonderful, and it's the challenge all academics have to get all the ideas out in a few minutes when you've written a long article, and encourage everybody to download that piece and see the full argument. A point you make, and that I think is just worth kind of reflecting on or reinforcing at this moment, is the idea that we would have in our state constitution an authority for the people to vote on legislation, and that was built around the assumption that the people needed to go outside the traditional legislative process in order to get something they thought was important done, and then would give plenary authority, presumably, to a complete repeal by that same General Assembly that next day. And I think that was the point you were making of like, that argument seems really inconsistent with what's in mind here. And so the idea that there really is complete discretion for the General Assembly to completely repeal, whether it was the cannabis law or any other law that's passed by voter initiative, seems problematic, both conceptually and structurally. And then we get to the nuance part, and this is the part that I'd like us to keep talking about. All right, even if we accept that the General Assembly can pass some legislation to facilitate, just not limit or restrict what the voters enacted, how do we give meaning to that in general, or particularly in the context of the ongoing debate over reform of issue 2? And then I guess B is, who's going to adjudicate that? I presume it's going to be the courts, and that's the expectation. You mentioned some Ohio Supreme Court rulings, so they've addressed this to some degree. But to the extent that your reading does still enable some facilitation efforts, I sort of want to sort of play that out a little bit more. Do you have a sense of how that should be approached, or kind of where the gravity of that argument takes us in terms of the inevitability, you might say, over time, of General Assemblies wanting to get involved in any complicated sphere that obviously marijuana regulation and legalization necessarily involves?
Yeah, and that's a very important question. And so I think the standard amounts to something like heightened, if not strict, scrutiny. And where I'm pulling that from is actually a Utah Supreme Court decision that came out last summer, deciding almost a very similar version of this question, and reaching this conclusion that the Constitution, even though it doesn't specifically address this scenario, does provide protections. And the court said it amounts to strict. The Utah court took the position that it amounts to strict scrutiny protection for the people's right to reform their government through citizen initiatives. So I think in practice, the way this would look is, I think there are certain changes that very well could facilitate and initiate statute without in any way limiting or restricting it. I think that includes like minor or technical stylistic revisions, as well as modifications to ensure that the initiative functions properly. Lawmakers could also maybe expand upon initiative provisions so long as it's in a manner consistent with the initiative's purpose. And I think lawmakers could also legislate on issues related to, but not explicitly addressed by the initiative. So I think that's how this plays out in practice. I mean, just some examples come from the last statutory initiative that Ohioans approved, which was a 2006 indoor smoking ban. And if you look at the history of that, I don't know whether or not lawmakers intended to. I think their changes have actually been pretty consistent with this idea of facilitating the initiative. They've made tweaks over the years. They allowed for maybe expanded enforcement of some of the provisions that were in the initiative. And at some point, they expanded the ban to include vapes and e-cigarettes, which I don't think were really a thing in 2006. And I think that gives some examples of just what the standard could look like in practice.
And I'd be inclined to give a very specific example in the context of the marijuana initiative. There's been some talk about, even though there was a designated allocation of where the tax funds go, there wasn't a provision that directly operationalized getting the money, to the various agencies and departments that had been allocated under the initiated statute. So presumably the legislature could pass instructions on how to do that, how to get the money consistent with the 36%, 25%, 3% allocations that were put in place. But if they were to take an eraser and dramatically change those numbers, now whether a small change in the tax allocations, I'm going to turn to Patrick and Karen now to get their sense of what would or would not pass strict scrutiny. Though I have one last question, because I think I know the answer to this, but I want to make sure I have it right. Derek, under Ohio's law, any challenge to what the legislature the General Assembly would do here, that would go straight to the Ohio Supreme Court, or would it get litigated in the lower courts and then eventually get to the Ohio Supreme Court? Because process always matters, I know, as a lawyer.
Yeah, I think it would be litigated in lower courts first. There is language in the Constitution talking about any challenges to an initiative petition. Those can go straight to the state Supreme Court. I don't think this would fall under that, though, because we're not talking about the actual petition. We're just talking about this after this post-petition process, really. And so I think it would go through the lower courts first. And then almost certainly, if it would almost certainly make its way to the state Supreme Court.
Oh yeah, so that's my setup to now putting Patrick and Karen on the spot. Now Derek's laid out the idea that anything the General Assembly were to do to change issue 2 would be subject to a kind of strict scrutiny, presumably under the notion whether that change is facilitating, I don't know if you'd quite say the will of the voters or what the voters enacted in issue 2, or instead serve to limit or restrain what the voters were voting for. Someone's asking you to put together the complaint to go in the Court of Common Pleas, saying we're violating the Ohio Constitution with that provision in the General Assembly. Which provisions are you going to target? Which ones do you think are most concerning to you? Which ones do you think would be easiest to argue shouldn't pass strict scrutiny when we see what's been done? I'm inclined to guess both of you will say some of the criminalization provisions, though it seems like some of those are backing away. I'm eager to hear what you think would be not so much the easiest to attack, but you think are on these terms the least likely to look like they're facilitating what the voters asked for rather than limit or restrain it.
All right, I'll make a first stab at it. I think Derek's own article explains that the recriminalization, I believe, and the moving of the allocations, removal of the allocations are both vulnerable under such an analysis. I unfortunately have become a little bit cynical of some courts in the last few years. So I think it's important to fight it out with the legislature first and to make the case.
Well, I want to pause on that, Karen, because I think your cynicism is probably based in experience in other states. But can you just speak to that a little bit? Because, even though I think those of us who follow these debates and have seen what has happened in some other states in court fights over voter initiatives, it'd be useful to kind of better understand your scar tissue here, maybe.
Sure. So Nebraska single subject law comes to mind. There was a heroic effort by a bunch of medical cannabis families and loved ones to qualify medical cannabis for the ballot in 2020. It was a very short, simple initiative, similar to ones that have been on the ballot in many, many other states. And the court ruled that it was 8 subjects. And these were like the one person possesses marijuana, what the qualifying conditions are. I don't remember all the specifics, but there were little tiny minutiae that required them to then, for the most recent initiative, have 2 different petitions that were exceptionally short to reduce the chance of single subject ruling. And of course, we've seen at the federal level some decisions that many of us would never have expected, with the overturning of Roe and other things. So while my hope would be that the court would find that that these changes, including recriminalization, removal of the stores, the additional licensees, and that change of allocations is unconstitutional, and that's entirely possible. Utah, ruled that their changes to the initiative by the legislature were unconstitutional. So it's entirely possible, but for this reason, I would never take it for granted that how I think the law should be interpreted is how it will be.
I appreciate that. Yeah, there's been some writing and broader discussion of the ways in which we've seen some state courts rein back their commitment to direct democracy in the context, particularly of cannabis reforms, because obviously that's a controversial topic in a variety of ways, and one that often the so-called insiders are troubled by some of the reforms that the voters enact. But Patrick, how about you? You have other things in your sights here?
Sure. Yeah, I'm going to do my best not to stick my foot in my mouth when speaking on behalf of our whole team. I'm a member of our policy team and not our litigation team. But if I were to step back for a second, put on my robe as Justice Higgins, and look at this through Derek's proposal, what we're looking at now isn't just an implementation bill. It didn't start that way. It's not where we are now. Just because the version of the bill that we're looking at now is better than what we started with, I would still argue that this is not good policy that institutes the will of voters. I think, remaining in the bill is something right now that, issue 2 allows private landlords to prohibit, some cannabis conduct in their properties. The Senate Bill 56 that's pending right now goes so far as creating a criminal offense for violating a lease where a person violates those cannabis provisions. And so, I don't want to speak in absolutes, but this is certainly something that's troubling when we look at what the reasons we supported issue 2 and where we're at now. I think, especially when we're talking about tax implementation of some of those programs, we're looking at social equity and jobs program. Totally wiped out, both in Senate Bill 56 as well as the budget, and it's something that I think makes that case. We've heard committee testimony and opinions from legislators that they think certain pieces of that might be unconstitutional or unimplementable, but the common refrain in the State House is it's called the revised code for a reason. We can make tweaks to it. We don't have to throw the baby out with the bathwater. And that's exactly what we're hoping this legislature will keep in mind. By forgoing the process by which folks could opine on this before it went to the ballot, we've seen numerous opponents to this bill come out who are able to participate in the process. And I think the message has been resoundingly clear, is that this is not what voters wanted. This is not what they want to see going forward. And still, the legislature presses on. So I am sorry to skirt the question a little bit, but
no, you did great. In fact, I'm going to pick up on part of it and bring it back to Derek for a minute, because partially picking up a question that's in the Q&A as well, is I think the social equity and jobs piece of things was definitely something that many voters cared about, and obviously was a big part of the proposal that went directly to voters back in 2023. But as Patrick mentioned, there's some talk about whether there could be some constitutional questions about it. Obviously, if there are federal constitutional concerns, that's something that we would expect our General Assembly to care about. And is there kind of an argument that, maybe this is under our state constitution closer to a limitation or a restriction, but we feel compelled to head off the possibility of a federal constitutional challenge? Or, does maybe the different way to say is the motivation or the driving force behind making reforms significant in judging whether this is kind of a good faith modification? I'm not sure if good faith is exactly the right way to read the text and structure and history, but I'm wondering if you have a sense of whether certain kinds of arguments, when we talk about the tax revenue, my instinct is the General Assembly is just like, we want to put it all in the general fund, and we got no other motivation, and we want to control the money rather than leave it to the way the voters did it. but when it comes to maybe some of the other provisions, they'd have other kinds of claims for why they felt like they needed to make a modification. Do you think that matters in the analysis, or do you think it's ultimately, maybe that's part of strict scrutiny, but you need an awfully good argument to justify making a big change like that?
Yeah, that's a great question, and I think it comes down to the state would need a pretty good argument to justify that change. I think it gets tricky to just say, the fear of a lawsuit can justify changing what the voters approved. So that gives me some pause to embrace that. But certainly, I think if there was a court ruling saying it was unconstitutional, then I think that would somewhat free up the legislature to change the policy.
Do you sense, and this is maybe not what you've thought all the way through, but I think it's what any possible litigants would need to think through, with the reform law that the General Assembly passes stand and fall as one big unit, or would you think courts have authority to come in and say, well, the tweak to the tax revenue, that's facilitating, that's okay, but the recriminalization, that's a limitation, that's struck out, almost like a constitutional line item veto? Would that be the way in which this litigation could function? Or at the end of the day is, sorry, you passed a bill that has limits rather than just facilitates, so the whole bill gets wiped off and try again, General Assembly?
Yeah, I mean, that's a really interesting question. I think the more likely outcome would be, just targeting individual provisions. I think that's what a court would most likely do, and probably trying to keep up and not keep up, but certainly maintain as much as it can, rather than taking this big sledgehammer approach to the reform.
Very good. I think that certainly would be strategic for the potential advocates to not ask the whole bill to come down, especially as seems possible, this ends up being part of the budget bill as well. And so, there's that's, I think, an important component of imagining how litigation might go forward. I want to, before we run out of time, are there any other possibilities out there? I know voters and folks who put the initiative before voters in the first instance seem to strongly support, existing reforms. Would another initiative process, could we referendum any General Assembly change? I know it these days costs a lot to get anything directly to the voters, and I'm thinking about this question in part because of which way that cuts to possible litigation, right? If there's a realistic chance that, another round of changes could be coming before the voters, maybe courts would be disinclined to get involved. But if, practically speaking, it's extremely unlikely that we would see another initiative process, and Karen, maybe some of this from seeing what's happened in Nebraska or some other states, that might influence the courts to feel like they do need to play more of a role to safeguard voter interests, when it seems awfully unlikely that there wouldn't be another significant campaign to get these issues to the voter.
Yeah, unfortunately, I would not think it would be very likely that there would be another initiative on the ballot. They are exceptionally expensive to collect the signatures to put the question on the ballot. Over $7 million was spent on issue 2. I'm not sure where the funding would come from for that heavy of a lift. So I think the better tack now is contacting folks on state legislators, especially your state representative, to let them know your concerns. As I said, we've seen a lot of whittling away at how terrible the bill is. And so I think it's important to keep raising the voices. And then there's always the possibility of litigation, as Derek has outlined as well. So it's possible, but it would be a huge, huge, huge lift.
Can I add something to that? I think kind of pushing back on the not pushing back, but agreeing with Karen, pushing back on the notion that there might be another ballot measure is, I mean, let's say a veto referendum goes forward, and let's say the voters, reject the changes. Under this legal theory of the General Assembly's adopted, they could just do it again and again and again, and just keep forcing this process until the people tap out, I guess. And same with another initiated statute. If you take the view that the General Assembly can change it, why would you even bother trying again? So, I mean, maybe there's an initiated constitutional amendment, but yeah, as everyone has said, those are very hard, very expensive. And so I don't know how that would happen, or if it would happen.
That's a very excellent point, and one that sort of highlights how all these things move, in a kind of logical way, if and only if your vision that there are real limits on what the General Assembly can do has some functioning, right? And we've actually seen it ultimately failed, but an effort by the General Assembly to raise the amount of votes required for a constitutional amendment, but then leave the legislative amendment level in place, again, maybe based on their desire to believe they can do whatever they want if something passes through that mechanism, but then you really end up gutting this alternative path towards voter impact. And so I think that's it's important to keep in mind along the way. Patrick, I don't know if you have more to say on this. You've seen sort of these policies play out, for a number of years.
Yeah, it's you caught me just reflecting on that actually, which is, in 2023, ACLU of Ohio was also part of a coalition that put issue 1 on the ballot, and we saw what happened there through constitutional amendment, the reaction from the state legislature, setting up an August election that they had actually just taken out of the law in order to stop that effort. If I'm reading the tea leaves correctly. So, it's something that through that process, lawmakers said again and again, no, we need to raise this threshold for constitutional amendments. Y'all still have your state initiated legislative or state law process. You can use that. You don't need to amend the Constitution for everything. And here we are, a year and a half later, and we know what those words meant, which was stop doing this, do the thing that we can roll back the minute you pass it. So, I think when folks are thinking through this, talking to lawmakers about it, it's important to keep in mind what they've told us. If you really have a respect for this process, let's see it play out in this General Assembly.
I see some questions in the Q&A about, is it possible that the policy pressure is already slowing the House down, that maybe something won't get passed? Maybe I'll just, before we kind of do wrap-up comments, Karen and Patrick, do you think there's any chance that this gets punted yet again? A bill made it through one House way back in December 2023, if I remember correctly, and then it didn't get all the way to the governor's desk. There have been other bills that have been making the rounds for the better part of a year. I've certainly been targeting the budget cycle as the one that seems like when something would definitely get done, but is there a chance this will just continue to get punted and that issue 2 will stay in place just because they can't quite figure out how much they want to, dare I say, skirt the line between limitations and facilitation?
I suppose it's possible, but I think it's unlikely. I think by far the most likely scenario is that something passes. There's a very strong desire. The bill also has changes to hemp regulation, which issue 2 didn't touch, requiring hemp to be sold through dispensaries, currently with the exception of beverages. And some of the strongest champions, at least on the Republican side of the aisle in the committee, like Representative Jamie Callender, have said, that the amendments are getting closer, but he'll have more amendments. So my sense is that it's a question of what it will look like and not if it passes. Anything's possible, but it looks like it has a very strong chance of passing with amendments.
I share this outlook. I think, dates to be aware of for folks that are tracking this from home. Budget's got to get done towards the end of this month before lawmakers go on a summer break. We've also heard through the committee process and from the sponsor of the bills that they desire to get this done in June as well. So, a few things also to keep in mind. I saw there's a question in there about neither of these bills, neither being House Bill 160 or Senate Bill 56, is on the House Judiciary agenda for tomorrow. As some folks know, House Judiciary generally meets on Wednesday mornings, and then that makes it awfully convenient, I guess is the word I'll choose, for that committee to pass a bill that then ends up on the House floor, where House session takes place and is scheduled every Wednesday afternoon between now and the end of the month. So there are ample opportunities before the end of the month for this committee to move this bill out of committee and put it on the House floor for a vote. So yeah, I'll put that out there. There's opportunities to do so. I would also point out Senate Bill 56 has already passed the Senate, and just as recently as a couple weeks ago, I think the House Judiciary Committee amended all of its language into Senate Bill 56, which creates an interesting procedural scenario where now the House can make its amendments and then send it back over to the House or back over to the Senate for a quick concurrence vote. So while the runway might seem short, it is definitely legislatively possible for this bill to get done, whether through the budget or not.
Thank you. That's very, very, very helpful. And, I see another Q&A question about whether there's sort of talk of another amendment effort with constitutional override here. And my sense, we talked about this a little bit earlier, that is really expensive. I don't think that's particularly likely. I think it may explain in part why the General Assembly has ratcheted back some of the worst provisions, is that the more egregious this is to a variety of constituencies, the more likely they'll at least talk about another round of reform. But I think, at least as the bill I've seen in its latest iteration, is unlikely to trigger, especially some of the economic interests, to be so troubled by what's going through that they would mount the full campaign to do a constitutional amendment. Against that backdrop, I'll highlight one last particular point and then have Derek maybe get the last word, since he got us to do all the words here with his great article. I think there's 90 days from when any reform gets passed until it goes into effect by law. I'm not going to ask you to be a constitutional litigator at this moment in Ohio, but that would seem to be enough time to at least bring a complaint and seek an injunction to try to stay a provision that was alleged to be limiting or restraining. From your look at the history and the research, I mean, is this something that can get gummed up in the courts for a long time, or is it something the courts are going to be, fairly quick to address? And we've heard earlier a little concern about whether they'll be as sympathetic to people complaining in this context as others. But if you had to predict, I guess, will there be litigation in that 90-day window, and is that the kind of thing that can slow down reforms in light of what you've read about past debates over these kinds of provisions?
Yeah, I agree that 90 days is plenty of time to file a complaint. And I know, legal challenges to new legislation are often brought in that time frame before the laws take effect, and you can often get, preliminary injunction or a TRO, something that can keep it from going into effect. And so I think something like that is very possible. I have no inside knowledge if anybody is planning to bring a lawsuit. I just want to make that clear. I think there are plenty of people who would be potentially interested in filing one and just going through all these different changes that Patrick and Karen highlighted. So I think there's a lot of potential plaintiffs. I think a lot of people could be looking at it. And I would expect it to kind of probably go through that preliminary injunction route, and then maybe that is what kind of goes up to the courts more quickly.
Very good. Well, so I will, as our time wraps up, encourage everybody to stay tuned. We certainly at the Drug Enforcement and Policy Center will continue to keep an eye on this, and want to thank all of you, not only for making the time to talk through these issues today and all those in attendance, but also hope you won't mind us knocking on your doors again if the drama continues to unfold, not just with what the General Assembly might do, but whether there could be litigation and future legal and ultimately political follow-up. And so anybody wants the last word, feel free to jump in. But with that, I certainly feel like we've covered an awful lot of ground in an hour, and I'm incredibly grateful. Go ahead, Patrick.
Sorry, just real briefly, in between that time now and when the bill we think will pass, your state lawmakers have phone numbers, they have addresses, email addresses. Lots of times they work with the kind of anonymity of not being known, Cap Square not being known in the same way that Capitol Hill is in Washington. So if you don't already know who your state lawmakers are, I think it's legislature.ohio.gov. You can enter in your address, find out who represents you, even if this is your first point of contact. Give them a call, show up at their office, shoot them an email, let them know how you feel about this, because that timeline discussion in mind, we are certainly on a limited timeline now, and now is not the time to wait. So had to get that plug in there. Appreciate the extra minute. Thank you.
A terrific point, especially as we're wrapping up, making sure the will of the people are heard. Remind people they're the people, and they should let their views be known to our representatives. So with that, thank you all again. Really grateful and appreciative for your time and energy today. And please feel free to follow up anybody in the audience with the Drug Enforcement and Policy Center. You've got links in the chat. This will be online in a few days, and we look forward to continuing to cover and talk through just all the complicated and important issues that these topics raise. So thank you again. Have a great afternoon. Look forward to seeing you all soon.